Speaker, this is I think, a pretty interesting
In the House of Representatives.
Oh, please. Gosh, I'm sorry. Let's see. I request unanimous consent that we suspend further reading of House Joint Memorial 2.
Unanimous consent has been requested. Is there objection? Hearing none, the good gentleman now has the floor.
Gotta start over again. This is an interesting memorial because although the heading, not on the memorial itself, but on the list of bills today says abortion, it's really about jurisdiction. As many of you know, the United States Supreme Court is the only court created by the U.S. Constitution. The rest of the courts are created by statute, by Congress. After the Dobbs decision struck down the abortion law for 50 years, it specifically addressed the issue of the state power and authority to direct this issue. So Roe v. Wade was not just struck down, but the issue was put back where the court said it belonged. And if you read some of these quotes from the Dobbs decision, it's fascinating to see how they were clearly saying that this never should have been taken from the power of the states. So all this memorial is doing something that you would think at first is unique, and that is saying to the Congress, restrict the power of federal district courts away from inability to rule on state sovereignty issue like abortion. But this has been done before. It's been done in the Wolf case. It's been done in at least a couple of other times where the Congress reacted to the negative and the jurisdiction of the federal courts and said, this is a state issue, you no longer have any authority to hear these cases. So this resolution is simply asking Congress to do the same thing it's done before, only with respect to abortion cases, because clearly from the Dobbs decision, it's state concerns, not federal concerns. I'll stand for any questions. Thank you, Mr. Speaker.
Thank you, gentlemen. You've heard the motion. Is further debate on the motion? Good lady from 18.
Thank you, Mr. Speaker. To debate against the motion.
Good lady has the floor.
Thank you, Mr. Speaker. I think that this resolution profoundly misstates what the ruling was in Dobbs. Dobbs did not say that there would be no federal jurisdiction with respect to abortion. It simply said that it was their conclusion that there was not a constitutional right to privacy implied in the Constitution, pursuant to the 9th and 14th Amendments, etc. They did not exclude the possibility that there could be other sources of federal jurisdiction. They didn't rule out the possibility there could be federal laws that would have bearing, such as EMTALA, which is currently being litigated. Nor, frankly, did they foreclose the possibility that there could be some other constitutional basis for federal jurisdiction regarding abortion. They simply said they don't buy the right of privacy that was set forth in Roe. It was not an open season saying only state courts have jurisdiction over this. In fact, I bet many folks would be changing their tune if there were to be a federal ban on abortion. I think then maybe folks would say they love federal jurisdiction over abortion, and would contest whether blue states would in fact have any jurisdiction to permit abortion. But this just is simply not legally accurate in terms of what the ruling in Dobbs was. It still left plenty of room for there to be lots of say for federal courts, and I don't think we should be passing resolutions that are legally and factually inaccurate.
Thank you, ladies. Further debate on the joint memorial? Hearing none. Gentleman 17.
Thank you, Mr. Speaker, to debate the bill.
Gentleman has the floor.
Just point out that the Dobbs decision was a decision that went through the federal court system. The federal court system has been here since our Constitution was put into place. And we don't limit the jurisdiction of the federal courts very lightly. There is no reason to pass something like this when it was the federal court system that made the decision that many representatives like. It was the federal court system that made the decision. So why is there any fear about having the federal court system still involved in this very difficult and legally complex issue? Thank you, Mr. Speaker.
Thank you, good gentlemen. Further debate on the memorial? Hearing none, the gentleman from 3 care to close.
Thank you, Mr. Speaker. I find it fascinating that the accusation of being fearful of the federal courts is propounded. It's not fear, it's jurisdiction. And I'll read from the resolution itself, Mr. Speaker, on line 24 there, page 1. Procuring an abortion is not a fundamental constitutional right because such a right has no basis in the Constitution's text and in our nation's history. So this is not just about privacy. This isn't referring to privacy. This is referring to the issue as not being a constitutional issue. All we're saying is asking the Congress to limit the lower federal court's jurisdiction such that states and state jurisdiction within respect to both jurisprudence and legislature stays within the state. Thank you, Mr. Speaker.
Thank you, good gentleman. Debate is closed. Question is House Georgia Memorial 2 pass the House. Clerk will lock the machine and the members will record their votes. Has every member voted? Representative Birch, Representative Monks,
Party line.
some members should change their vote. Clerk will lock the machine and record the roll. 56 ayes, 12 nay, 2 absent excused, majority having voted in favor of House Joint Memorial 2. House Joint Memorial 2 is passed the House.